sir, for allowing me to speak on the Criminal Procedure Identification Bill 2022. The speakers before me from my party, it happens to be a sheer coincidence that though we are all members of Parliament in the Lok Sabha, all of us also belong to the community of civil servants. The first two speakers come from the IPS, and then my senior from the Indian Administrative Service, Srimati Aparajita Sarangi. But I must confess that when I realized that my first two speakers were from the IPS, by instinct and training, the idea is to restrain the police. That's what one has learned during training, and then in 21 years of service, out of which 12 were in the field. But when I read this particular bill and the provisions therein, I have to confess that it was a case of der aaye durust aaye. The Law Commission, as early as 1980, had recommended widespread changes. In fact, it stated that there is a need to make it correspond with the modern trends in criminal investigation. This is when they are talking about changes to the Identification of Prisoners Act of 1920. It is this act which this bill seeks to repeal and replace. And in its contents, it's a small bill. It just has 10 sections. But the kind of storm it has raised in the Parliament when it was introduced, and also today, looking at the number of participants who've spoken on this, I have to say that there is a lot in this bill which needs discussion and has been discussed today, and I'm sure we'll all come out of this discussion much wiser. The bill, as I said, seeks to repeal and replace the 1920 Act. Where was the need for this? It is not as if there was an immediate court case and the government had to come up with a new bill, or if there was some other pressing need. The thing is, it just had been waiting, and it had been in the waiting for far too long. Many states tried to bring about piecemeal changes or amendments to the Identification of Prisoners Act of 1920. These states include West Bengal, Gujarat, Karnataka, Maharashtra, Tamil Nadu. And the last case was of Karnataka in 2021, when they did seek to expand the definition of measurement and to include DNA and voice and iris scans. However, this bill was reserved by the governor for consideration of the President of India, because it was felt that this bill was repugnant with the Act of 1922, which is a central act. And so we are where we are right now, and it has been said as if everything in this bill is new. 1920 Act provided for three things in terms of measurement. It provided for fingerprints, it provided for footprints, and if the magistrate so desired, photographs could also be taken. But then it had to be, but we also have the provisions from the CRPC under 53(1) and also 53A and 54, especially these two. The explanation provides as under, and I quote, examination shall include the examination of blood, blood stains, semen, swabs in case of sexual offences, sputum and sweat, hair sample, and fingernail clippings by the use of modern and scientific techniques, including DNA profiling and such other tests which the registered medical practitioner thinks necessary in a particular case. Why I bring this up is because a lot has been made about the legislative competence and how perhaps it violates the issues of privacy. These have been in existence already, and they have stood the test of time, and they have not been declared as violation of personal liberty by any court so far. This bill, however, takes it a little further and includes certain other things wherein the 1920 Act was found to be inadequate. And I must say that most of us in our younger days have read detective novels of Arthur Conan Doyle about Sherlock Holmes and what a bright man he was, what uncanny sense of perception he had. But a Sherlock Holmes in today's day and age, with his magnifying glass, would look like an investigative dinosaur. A 1920 Act, which provides for only fingerprints, footprints, and photographs, is not the way to deal with crime and criminals of the 21st century. We cannot expect our police to be equipped with tools of early 20th century to deal with crimes and criminals of the 21st century. The modern techniques, the modern technology which is available to all of us, it provides for a triangulation that is now possible, which was unthinkable a century ago. Now joining the dots using different identification techniques greatly facilitates and enhances the quality and quantity of the criminal investigation. As our Home Minister said in his opening remarks, the idea is to get the conviction rates up. And those cannot happen unless scientific methods are adopted and used by our police forces and prison authorities and in the overall criminal justice system. Only then such an improvement is possible. The previous Act of 1920 was also limited in its ambit, and the present bill seeks to expand it further by including what is referred to as other persons. It is, though most of it is from the previous Act, where a convicted person, his measurements can be taken, then someone who's been ordered to give security for his good behavior, he can be asked to give his measurements, and someone who's arrested for any offense existing under the law. But yes, the police powers in the present bill have been increased. The magisterial powers remain the same. They have not been tampered with. But the police powers have been increased. But in this day and age, when you have multiple sources available as far as data is concerned, you have the banks. Through KYC, they have almost all your data. You have the Aadhaar. It has your biometrics in any case. You have the Election Commission. It has a lot of your details. And all these private players, whether it's Google or Microsoft or whichever company is dealing with these meta databases, they all have data. So just to restrain the police from not collecting data, which will be useful for them in an investigation and execution of cases before the court, somehow seems to be just a measure which one has to do away with, and we must move with the times, and we must use the modern techniques and technology which is available to us. Sir, I will point out just two things, because a lot has been made about privacy. Sir, just 2 minutes, sir. There are two provisos which are very important. They've been mentioned. Proviso under Section 3, where the person is given a choice. No one used this word, because otherwise this is a very, this is the word in common parlance as far as the liberal world is concerned, choice. A person is given a choice where it is said that he may not be obliged to allow taking of his biological samples, and there are conditions with this. So there is a choice given to a person. It's not as if it is not given. And in any case, there's a plethora of judgments wherein criminal jurisprudence may is generally read as shall. So it is almost a given in this. Similarly, proviso under Section 4, it provides that the measurement will be destroyed. It will be destroyed if the person has not been convicted before and if now has been discharged or acquitted by the court of law. So that is to be destroyed. So when we say that under trials and political protesters or activists, and when they are arrested for something, then they are clubbed with the hardened criminals or those who are committed with those who are charged with serious crimes. So that does not hold, because if the person is not convicted or if the person is discharged before that, so the data which has been collected in that case will be destroyed. Lastly, sir, since I don't have the luxury of time, one point which has been very conveniently missed out by everyone is that this bill provides for a great amount of legislative oversight, because ultimately this bill and its effectiveness and efficacy will come from the rules which will be framed under this act by the central government and by the state governments. And these rules, each and every rule, will have to be brought before both the houses of parliament and before the state assemblies.
आपका बहुत-बहुत धन्यवाद. The criminal.
Let me conclude by saying that no society is perfect, nor is ours. There are deeply held biases and prejudices embedded in our social consciousness. Our police is a product of its social milieu, and as such is far from being perfect. However, that does not mean that we do not empower it with requisite powers and instruments. There is an undeniable need to strike a balance between protecting an individual's privacy and giving the police the tools they need to keep us safe. With these words, I support this bill and urge this House to pass it in the right spirit. Thank you.